Thank you, Lenka. Thank you for inviting me, and thank you for Tom for his presentation. As you can see, I'm looking at best practices in protecting from and dealing with retaliation, and Tom suggested lots of avenues. I think I agree with everything. I'm going to dwell on some of them. I think I have time to make other comments as well, since Tom has done such a comprehensive survey. I think I'd like to open up with one comment on what I've heard today, and that is the need to protect people from retaliation. One of the things that we come across in the academic world in terms of research is finding out what works and what doesn't work. One of the things that's under-researched are the circumstances in which people blow the whistle successfully, that they don't suffer retaliation. That's not newsworthy. We're here today to deal with what is newsworthy, what is a tremendous problem, but we ought to be aware of the fact there is such a thing as successful whistleblowing, and we need to know more about that. A recent study in the UK of health service employees for the purposes of an independent inquiry showed that there was plenty of bullying and harassment going on of whistleblowers. That we found about 14–15% said they suffered a detriment for reporting a concern. That means there's an awful lot of people who didn't suffer a detriment for reporting a concern. So we need to know about that. So I will concentrate on my brief today, but I do think we have to bear in mind that we can't define whistleblowers on the basis that they've suffered retaliation. It's a very historic way of looking at it. There are such things as whistleblowers with good experiences, and those experiences need to be shared, which ties in with one of the points I want to make in a moment or two about management responsibilities. It is management's responsibility to facilitate whistleblowing and, of course, to share successful whistleblowing experiences. I'm going to run through these topics. The general management responsibility, this is not new. The management responsibility, of course, to have a culture where people feel free to speak up, that's a normal day-to-day occurrence, that people are not coerced. It's argued in Scandinavia, like in Norway, when you ask about whistleblowing, they say, what's the big deal? We're in a democratic system, and our employer, our trade union, welcomes us speaking up. I want to, in terms of what's on the board here, I want to talk about assessing the risks. It's quite interesting. This is something that employers should be doing, but in Australia there is a statutory duty on the federal agencies to ensure that risks are assessed. So this is something that employers should be doing, but the legislation can provide for that. Confidentiality and anonymity, well, those points have been raised by Tom. I will say little more about that. The question about who should be protected, again, I'd like to say a bit more about that. It's not obvious. One of the problems we have with legislation around the world is, as Tom indicated, a tendency to focus on workers' rights. But whistleblowing is about freedom of speech. It's about the rights of citizens. And the European Convention on Human Rights is about the rights of citizens. So we've got to decide whether whistleblowing legislation should be employment legislation, or should it be more all-embracing. Again, protection of third parties, it's worth looking at that. Tom has mentioned that. Third parties can be affected. Again, my experience of researching whistleblowing in the health service, one asks questions, well, who will have information? Who will have information about wrongdoing in the health service? It may be somebody who's employed, it may be a nurse, maybe a doctor, maybe an administrator, but wrongdoing may come to the attention of patients and members of the public. Their families might be affected. If treatment is affected, if a person's treatment is affected, third parties may be affected. So we want to have a wide spectrum of who can report. We need a wide spectrum of protection. As Tom's indicated, employers are ingenious in terms of the forms of harassment. And one obvious form of harassment is not to pick on the whistleblower, but to make threats against their family and friends. The issue of a criminal offence comes up. Tom's commented on that, obviously on burdens of proof and oversight. So those are the themes. I should have time to development, and I'll proceed to do so. In terms of management responsibilities, the law is a backstop. It has to be stated that this is not rocket science. If you read codes of practice, whether it's the British standard, whether it's the recommendation from the Budgetary Control Committee of the European Parliament, you're not going to change everything by passing a law. As Tom said, some of the laws are not worth having. Indeed, I'm highly critical of the UK legislation, which 15 years ago might have been a model and certainly is no longer. In terms of protection, there is the need for management to say we encourage people to report, it's a good thing, and those who inhibit the reporting of wrongdoing will have to face the consequences. So the culture of reporting can't be imposed, it must be demonstrated. You can't just have a statement saying we want people to speak up. You've got to demonstrate to employees, if we're in a workplace setting, that this is a reality. If you want to have a culture of encouraging reporting, you have procedures, you should be able to demonstrate that they work, and you should communicate the value of whistleblowing by reporting to your staff. Again, Tom's mentioned the role of trade unions in the context of arbitration, I think, mediation arbitration. The role of trade unions cannot be ignored in the whistleblowing context. Trade unions deal every day with whistleblowing. Allegations made by their members, made against their members. If you want to have a culture of encouraging reporting, you need to have your workforce on board. You need to consult about the adequacy of procedures, how your whistleblowing procedures are going to fit in with other procedures, disciplinary procedures, grievance procedures, bullying and harassment procedures, which may be seen as an alternative by potential whistleblowers. So, in terms of protecting people from retaliation, the best way of protecting them is to make sure there are no threats to them in the first place, that the organisation, if it's capable of manufacturing a positive culture of speaking up, does so. I also recognise, of course, that in the real world there are going to be organisations that actually don't want to be open, don't want to encourage people to speak up, and can only exist on the basis of corruption. No whistleblowing laws are going to touch these people. Corrupt organisations are going to throw money at the problem and make sure it goes away. But I'm talking to you on the assumption that management want to respond positively, and that involves them having the procedures, implementing them, and communicating to their staff what is going on. So you have a procedure, you say it's been negotiated, either through staff committees or trade unions. You send reminders to individuals of what the procedure exists. You update it and you review it. I'm ashamed to say that in the UK, this doesn't go on at the moment. Employers are ticking boxes. They're copying procedures, they have templates, and if nobody uses the procedure, that can be used as a sign there's nothing wrong in the organisation. It's not a sign that the procedure itself doesn't touch the problem. So management responsibility is a considerable one. It's an important one. I've talked about some of the practicalities. If you want to deal, if you're serious about encouraging people to come forward, you've got to make it easy for them to do so. You've got to tell people how to report internally, how they can take the matter further if they're not satisfied at the first stage. Then you have to recognise, of course, that they may not be satisfied internally. You may want to direct them to regulators. If you direct people to the appropriate agencies, to regulators, you may avoid them going to the media. So management's got a responsibility to have a decent procedure, and I'm sure Richard will be saying something about the nature of procedures later on. But in terms of protecting from retaliation, I think I'm going to make one point now that probably one of the few points that hasn't been said already, is that disciplinary rules should provide for retaliation against disciplinary rules should provide that those who retaliate against whistleblowers are committing a serious offence. This is not rocket science. Disciplinary rules already say that if you bully or harass somebody at the workplace, that's a disciplinary offence. What needs to be spelt out is that the harassment or reprisals against a whistleblower is no different. That this is a serious offence, and like with criminal prosecutions, people have to be punished. They have to be seen to be punished. It has to be demonstrated that these rules are serious. So staff have to be made aware of the rules, and those rules should be consistently enforced. Again, if the disciplinary rules at the workplace provide that retaliation is a serious offence, individuals are going to need to be represented when those rules are invoked, which inevitably again brings in trade unions. So I think that's an important aspect. In terms of avoiding retaliation, it's important, I think, to see on the statute book in Australia that federal agencies must have procedures for assessing risks of reprisals. It's a legislative requirement, but the Australian legislation does not apply in the private sector. I firmly believe, as many people in this room believe, that you can't draw a line between the public and private sector. You have to legislate for both, and I would urge the Czech Republic to seriously require both public bodies and private sector employers to have arrangements for assessing the risks of reprisals. It's one thing to have a procedure. This is one stage further. I think the Australian system is good in that respect. Assess the risks. It's a big ask, but I think it's an appropriate ask, and we're talking here today about what is appropriate for the Czech Republic. I would urge consideration of that. In terms of confidentiality, again, it's worth noting the UK system, we don't provide, in order for the law to work, you have to be identified. You have to be identified as somebody who's raised a concern. Confidentiality, as Tom has rightly said, is subject to legal requirements, and an employer may be compelled to disclose the identity of an individual if they are revealing money laundering activities or some criminal offence. So confidentiality cannot be guaranteed, but subject to these constraints, measures have to be taken to say what confidentiality, can you not see it, Tom? Measures have to be taken demonstrating what confidentiality means. I'm aware in Ireland, for example, confidentiality is taken seriously, so that there are detailed schedules in the legislation saying what an employer should do in order to maintain confidentiality, what are regarded as reasonably practicable steps. And similarly, in terms of judicial proceedings, legal proceedings, it's possible to have a schedule that says the court must take the following steps in an endeavour to maintain confidentiality. So it's one thing to mention confidentiality, it's another to take steps to ensure that it happens. In an ideal world, of course, people would feel confident to speak up openly and whatever. That's an ideal world. The reality is that some people will only offer information, only disclose evidence of wrongdoing if they get guaranteed. And sadly, of course, in some cases that means that they will only disclose if they think they can remain anonymous. The problem with anonymity, as Tom has made clear and is quite obvious, there are occasions where your identity may not be revealed, but you will be identified by the circumstances because it was only you that could have made this disclosure. So anonymity makes it difficult to investigate. No employer wants anonymous disclosures, but equally no employer can disregard anonymous disclosures. What if what you receive is of a serious risk to the organisation, the draining of funds or health and safety? So anonymous disclosures have to be screened. They may be credible. The fact that the disclosure is anonymous may make it difficult to investigate, but it doesn't mean there shouldn't be some preliminary screening. Anonymity is not desirable, but it's better than nothing. It is better to have an anonymous disclosure of wrongdoing than people remaining silent. That's the problem we have, and it's something the Czech Republic has to address. If people have choices whether to disclose or not, they may remain silent because they are not satisfied about the safeguards. That may be in nobody's interest. It's very sad, but if people have choices, they will make them. They have a loyalty to fellow citizens. They have a loyalty to their employer. They have a loyalty to the state. But they have a loyalty to themselves and their families and friends. So we have to make it, we have to encourage people to speak out, and they have to understand the consequences of doing so. They have to understand that anonymity, their identity may be revealed, and certainly if they're going to bring a legal case, they're going to have to be identified. So I draw your attention here to Australia and Serbia. Australia telling us that it's okay to make an anonymous disclosure, and Serbia indicating that employers and authorities are required to act upon anonymous disclosures. It's interesting because in the UK we have an odd position where the individuals are protected. They can go to court if they've suffered retaliation. But that's the end of the matter. There is no requirement on any employer or recipient of the concern to take any action at all, which is a very odd system of having a whistleblowing laws. What are whistleblowing laws about? I'm here talking about protection and retaliation, but as Mark has indicated and needs to be reminded, whistleblowing laws should be about encouraging people to disclose in the public interest. We're not going to debate the public interest now, but it's about encouraging people to disclose. It's about facilitating the disclosure, about investigating the disclosure, and dealing with proven wrongdoing. It's not simply about protecting the whistleblower. The UK is in that position, and that's why I say that it was a model, but it is not a model now that the Czech Republic should give a due weight to. It can take best practices from throughout the world, and it will find that the UK is lacking in that respect. So anonymity is unfortunate. It's a fact of life, and I'm afraid we have to deal with that. In the ideal world, people speak up freely. In reality, that they're going to need some kind of assurance. In terms of who should be protected, I think a number of us have had a go at this. Tom certainly had a go. I draw your attention, it is from the latest Council of Europe recommendation, binding on 47 states, but it's very, very important that we should not forget that the Council of Europe addresses all individuals. It talks about the workplace, of course, but it talks about the public and private sectors. It talks about, says irrespective of the nature of their working relationship and whether they are paid or not. We have lots of problems in the UK and in Europe. Who are we talking about when we talk about employment relationship? Are we talking about somebody who is a worker, according to European definition, somebody who is technically an employee? There are different definitions, and that leads to some people not getting protection. Principle 3 talks about should cover all individuals. This covers, in my opinion, it covers those who do not have an employment relationship, those who are volunteers, agency workers, etc. So that I think is an important recommendation, and has already been alluded to. I also think there should be protection at the point of hiring, that people should be able to complain that they've suffered because they are a whistleblower, they've not been taken seriously. So these principles are there at that level, and many employers, of course, have taken this on board. If you are an employer, where do you want to hear about the alleged wrongdoing? Who do you want to hear it from? You want to know about it as soon as possible. You don't want to draw a distinction between who is an employee and who is a customer. You want to hear it from anybody. Many employers say that their whistleblowing procedures are open to anybody who wants to raise a concern. That's got to make sense. If you're in the public sector, it's quite obvious. A local authority delivering services. It will want the consumers of those services to give feedback. It will want members of the public to give feedback. And I'm pleased to say in the UK, well in advance of the legislation, local authorities are saying that their procedures are open to contractors, subcontractors, and members of the public. That's got to be right in principle, and of course is consistent with the notion that we're talking about freedom of speech here, not just workers' rights. Another issue that I think hasn't been touched on directly so far, I've talked about in Australia the requirement on agencies, public sector agencies, to assess the risks of reprisal. Again, I would urge the people in the Czech Republic to look at the idea of requiring employers to take reasonable steps to protect people from detriment. On the statute book, assess the risks, but to require employers to take reasonable steps to protect from detriment. This, of course, goes very much with the assessment of risks. And in Serbia, again, more recent, the Australian legislation, of course, is the Commonwealth legislation and is quite recent. The Serbian legislation also quite recent. You'll see my examples are from recent legislation. As Tom said, there are many countries have legislation. I've tried to take recent examples of good practice. So this is a positive duty, saying to employers, you have to take certain measures. I'm one of those people that say employers should have a statutory duty to have a procedure and to keep it up to date and to communicate it, to provide information. I'm not here to talk about that, but I think these measures are consistent with that. I can think of no argument why public sector employers don't have a whistleblowing procedure. I can't understand why private sector's employers wouldn't have a whistleblowing procedure. It is a matter of self-interest. I think it's incumbent on the state to say, it is in your interest to have a whistleblowing procedure, therefore we're going to make it a statutory obligation. I know having a procedure can cover a multitude of sins, but providing for internal reporting, if you've got a rogue employer, you give that employer the opportunity to conceal wrongdoing, whatever. But it does seem to me that if employers are going to have procedures, they should be good procedures. They should provide, amongst other things, for adequate reporting channels, and it should address the possibility of there being reprisals and put a burden on employers to contemplate that possibility. Another point that has been mentioned, and I've touched upon it already, it's worth spending a moment on it. It's a relatively new development, but it's a recognition in the law that other people may be affected. An associated person. In Serbia, an associated person shall enjoy the same protection as a whistleblower. That's really rather important, that people don't act by themselves. The harassment that may be suffered may be against family and friends, and such people need to be protected. Similarly, the question of wrongly believing somebody to be a whistleblower, that's addressed, and Tom's mentioned that already. If people suffer a detriment as a result of the whistleblowing process, they should be protected. They are innocents in that respect, and this is good practice. It's not going to come from employers. This kind of protection of third parties, I think, is going to have to come from statutory intervention. Move on now to when might protection be lost. So, one important point here, and others have dwelt upon it, and I'm going to raise it again because I think it's critical. This question of motive and and good faith. The experience in the UK is salutary. The UK legislation was originally based on the notion that employers would be protected if they disclosed in good faith. This was not seen as simply a question of honesty. It was a question of motive. The motive of the whistleblower, as others have said, is completely irrelevant. The motive of the whistleblower, drawing attention to the motive of the whistleblower, involves an examination of the messenger, which is a complete distraction from the message. If what the individual says is true, if the allegation is substantiated, how relevant is the motive of the whistleblower? So we have got real problems here. Even if you're interested in the motive of the whistleblower, how do you identify the motive of the whistleblower? The motive of the whistleblower is in the whistleblower's head. It can maybe assumed by the judge. And I'm pleased to say that in the UK, the judges actually recognised, when this legislation was enforced, that the motive of the whistleblower may be very different after their allegation has been rejected. They may be reporting in order to improve the situation. They may continue with their case after the employer said, we're not going to do anything about this. Their motive goes from utterly benign and open to one of wanting to get back at the employer who is not taking them seriously. Good faith still exists in legislation. I think it should be removed. And it's been taken out of the UK legislation, and I think it's something that people in the Czech Republic should bear in mind. Why was it taken out of the UK legislation? It was taken out because the lawyers were going for it. If you want to defend the company's engaged in wrongdoing, you can't do anything about that. What you can do is attack the motives of the whistleblower. So I would suggest to you that this is absolutely critical. The only circumstances in which protection should be lost, in my opinion, is where it can be demonstrated somebody has knowingly made a false or misleading statement. Obviously, you can't criticise somebody because they got it wrong. They misinterpreted something. And many whistleblowers do get it wrong. They see the brown envelope being passed from subordinates to somebody else, and they make an assumption that this is improper. It may be the return of money that's been loaned. But I think this is a very, very important matter, that whistleblowers will make mistakes. Whistleblowers will have a variety of different motives. What's important is whether they have an honest belief on reasonable grounds that there's something wrong. It's not up to the whistleblower to investigate. It's up to others to investigate. The whistleblower raises a concern. That's why you will see I was interested in what's happening in Bosnia, where it's stated in Article 9, the question of good faith is put in terms of knowingly submitting a false report. I like that. If you're going to have good faith, you define what you mean in that sense. This, to me, is a critical issue. Anybody interested in encouraging people to blow the whistle has to bear in mind that people will have mixed motives and they should not be deterred by potential examination of their motives. Okay, we're doing... Another example here from abusive whistleblowing should be prohibited. Again, I refer to Serbia because it's relatively recent legislation. This question of illegal gain causes problems as well. I'm not here to discuss rewards, but I do think this question of rewards is an example. Turning now to retaliation being a criminal offence. Again, people have expressed views on that today and about enforcement and the possibility. I take the view that making a reprisal a criminal offence is important, not because of the number of prosecutions. I'm sure there'll be very few prosecutions if this happened in the UK. There are very few prosecutions for health and safety offences by employers. But it's an important marker. It's an educative, it may have an educative effect. If employers went to prison for health and safety offences, which they do occasionally, that has an effect. I think if in fact there was personal accountability for employers and for individuals, it would have an effect. If we can make other aspects of employment relationships a criminal offence, why can't we do it here? In the UK, bullying and harassment can result in criminal sanctions. Why can't we apply it simply to whistleblowing explicitly? Not to supply a statutory statement in some countries is a criminal offence. So why not make reprisals a criminal offence? In the UK, we used to say, well, if the employer doesn't give detailed particulars of employer, that's a criminal offence. That seems to be, that's relatively, it's a minor infraction. So I know in the UK context, when I suggested this on the radio, the person interviewed me said, but this is off the wall, you can't do that. And I said, well, it may be off the wall, and I may not be able to do it, but this is what happens in the US and Australia. So I'm not pessimistic about that. I think I'm realistic about the number of prosecutions that will be brought. But I actually would like to see the criminal law having an impact on those who take reprisals. I don't think it's a step too far. Indeed, I think it's very sad in the UK that we have to use a piece of legislation, the Protection from Harassment Act, which was designed to be used against stalkers. Yeah, stalkers. We have to use that in order to find say there's a criminal sanction for those who harass whistleblowers. Thank you. I'll be well within 10 minutes. Be a relief to everybody. In terms of remedies, just to open up, because I've heard discussion before about possible remedies, I'm more optimistic about remedies. Tom talked about interim relief and reinstatement and all of that. I'm more optimistic. I believe that whistleblowers should have the choice of remedies, and whether it's transfer, relocation. But I can conceive of the possibility of a whistleblower wanting his or her job back if it's been removed. I've got reason to believe that that does occur via trade unions, via arbitration channels, whatever. That does happen in reality. I think that the law shouldn't give up on reinstatement. It should say to the whistleblower, you've been treated unlawfully, right is on your side, what remedy do you want? Do you want your job back? And I can understand a whistleblower saying, no, I don't. After the way they've treated me, I wouldn't even think about it. But if your case comes up 2.5, 3 years after you've been sacked, you're unemployed, and the person who mistreated you has been removed, you may think it's possible to go back. You've been vindicated. You may not want to, but you may think it's in your interest to do so. So I actually feel, contrary to what other people say, that reinstatement should be there. And the fact that it can be ordered, I think Tom was alluding to this, may put pressure on an employer. We always say in unfair dismissal law in the UK, when you ask what remedy you want, you always put down re-employment, whether you want it or not, because the employer will respond to that. They may fear that the court's going to order that. So reinstatement, I think, can work. The first slide I've got here is from Bosnia, the possibility of the Agency for Protection of Corruption and Coordination, the fight against corruption, issue an instruction to the director of the institution to remove the consequences of detrimental action. There's no such thing in the UK. No regulator can employ, no court or regulator can instruct an employer to remove the consequences of detrimental action, or indeed to stop any wrongdoing. So moving on then to the issue, showing you the slide where reinstatement is mentioned. In Australia, the General Civil Court jurisdiction then provides for reinstatement and unlimited damages. And as an alternative, the fair wages system, this is a new provision under the Commonwealth legislation, fairly recent, I think, 2013, so that in Australia they've taken in the notion of employment tribunals and workers being able to bring a claim based under the Fair Work system. It used to be that this was the remedies were only the public law remedies. So this seems to me the way forward. If you're serious about providing a remedy, you say to the whistleblower, you're in the right, you've suffered a detriment, whether you were right or wrong in your allegation, you should have the choices, and quite simply, if you want your job back, you should have it. If you want to transfer, you should have it. You should have unlimited damages, perhaps based on the motion that you'll never work again. I think courts have to be pessimistic about what will happen to whistleblowers. In that sense. Contrast that, of course, with something which I regard as a retrograde step in Ireland. I approve of the legislation there. The Irish government, I think, did what I hope the Czech Republic will do, look around the world and say, we want to have the best possible legislation consistent with our own circumstances. And in Ireland, the relevant minister said, I've looked elsewhere, in particular he said, I've looked at New Zealand, and I've looked at the UK, and I want to learn from their experience and their mistakes. Ireland, in my opinion, has done well. There are many measures there that I approve of, including giving third parties to bring an action in tort. What I don't understand in the Irish provisions, which are displayed on the board behind me, is why compensation is capped. Unfair dismissal compensation is capped. It seems to me wholly wrong. There seems to be something very wrong indeed if every other form of discrimination can lead to uncapped damages. If you discriminated on the grounds of sex, race, orientation, nationality, etc., you have uncapped damages. Why would you cap the damages for a whistleblower? In the UK, we've recognised that normally unfair dismissal compensation is limited. The average sum that's handed out is paltry, but whistleblowers can get unlimited compensation. Of course, winning your case in an employment tribunal in the UK is extremely difficult, and the number of cases has gone down owing to the introduction of fees. It's something that's already been mentioned before about access to justice, but there's no point in having the best legislation in the world if those rights cannot be exercised. You can actually have perfect legislation, but if people cannot afford to bring a case, they're in trouble. The system in the UK is worth mentioning. You pay a fee to lodge your claim, you pay a hearing fee, and you're about to say, well, if you win your claim, of course you get that back. No. There is no provision. You would argue it before the court, that's part of what you've lost. But the system says that you pay those fees. You may or may not get those fees back if you win. There's an expectation that you will, but it's very clear the courts have said no. That's up for grabs. I am moving towards the end. In terms of burden of proof, there can be no question about where the burden of proof shall lie. The burden of proof must always be on the employer. Once the worker has made a prima facie case, the burden of proof must be on the employer to show that there wasn't a detriment, once a prima facie case has been put that there was, and that if a detriment was suffered, it wasn't because of whistleblowing. This should be clear and consistent. It must be on the employer consistently. I say clear and consistent because in the UK we have two different burdens of proof depending on whether you're sacked or whether you've suffered a detriment short of dismissal. Now, if you look at me and say that's ludicrous, I agree with you entirely, but that is the case. If you have been dismissed, you have to demonstrate as a claimant, as a worker, that the principal reason for your dismissal was that you made a protected disclosure. If you allege action short of dismissal, a detriment short of dismissal, and you prevent a prima facie case, the employer has to show that the detriment was not because you made a protected disclosure. I can't defend this system. I don't know how the courts defend this system. It seems to me, however, in terms of good practice, the burden of proof at all stages has to be on the employer. Lastly, you'd be delighted to know, you can't see any slide, can you? Is there something there? You must pay the bills here. If you don't pay for the electricity, you won't see the slides. It doesn't matter. Lastly, the question of oversight. I think Tom's already mentioned that. It's very important to have some kind of labour inspectorate. We don't have that in the UK. It does seem to me it's entirely appropriate. You have a labour inspectorate that looks at health and safety matters, it looks at minimum wage matters, that it has some responsibility for seeing that employers are complying with any procedures that are required. So, if I pull the plug. There we go. It's just winding up. I'll just about finish before the power comes through. This has nothing to do with the NSA, is it? I'm going to finish by saying that there should be some oversight. Tom's mentioned about the reviewing legislation, having the legislation, reviewing the legislation. There should be some inspectorate, in my opinion. So I will conclude by saying...
Yeah, you can talk.
Yeah? Excellent. Having just got that, I now want to go back to the beginning, of course. It's gone again. I will conclude by saying I've tried to focus on best practice, on protecting whistleblowers and dealing retaliation. I would urge you in the Czech Republic to look at what's out there, to not look at one particular way of doing it, but decide what suits you. But to say that one model, particularly the UK model, is adequate is simply not true. The best practices identified by the Council of Europe, they've been identified by Tom. There are all kinds of international documents to draw upon. So I wish you luck and look forward to seeing the fruits of your labours.